Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. Ripple versus SEC lawsuit, key deadline announced for April and May. A new scheduling order was issued by Judicial Magistrate Sarah Netburn, who is presiding over the trial between Ripple Labs and the United States Securities and Exchange Commission, yes. The ruling was regarding Ripple's desire to exclude records and materials that were intended to conduct a remedies-related brief from the SEC. The brief presentation that the SEC made regarding the remedies section in which Ripple is involved is the focal point of the case. When the parties presented their proposal for the new scheduling order, one of the issues that was brought up was Ripple's request to strike the SEC expert papers. This was a demonstration of the parties' intention to resolve the issue. Magistrate Netburn has declared that the SEC is required to respond to Ripple's motion by the deadline of April 29, 2024. This complies with the order that was transmitted by James K. Phelan on X, which was once known as Twitter. Following that, Ripple will provide its rebuttal no later than May 2, 2024, which is 3 business days after the first date that was stipulated in the ruling. Because Ripple's response is slated to be sent on January 26th. Which is 4 days before the SEC will respond to the remedies arguments that have been presented in this matter. The accuracy of these files is of the utmost importance. The answer that is produced by striking the expert materials, primarily Andre Fox's opinion, has the potential to have a significant impact on the outcome of the measures phase of the claim. The Ripple case is becoming more contentious as experts report there. The complicated chain of events that occurred in the cases of both the SEC and Ripple is brought to light by the scheduling order issued by Judge Netburn. It was difficult for Ripple to provide analytical responses to the issues that were included in the expert report, according to his argument, because the introduction to the expert report was not very clear to make a point that is connected to the enormous amount of information that is included in Ripple's financial reports and the liability that is associated with its digitally sold asset, XRP. The authority of Andre Fox's expert assessment about XRP case cannot be questioned. Although the court may give the rule-to-rule basis defense substantial consideration, the SEC will reduce the amount of the punishment that it imposes, which will result in a reduction in the amount of monies available. In addition, the publicity campaign that is currently underway as a consequence of the nomination of Sarah Netburn to the position of federal judge in the United States District Court for the Southern District of New York City reduces the likelihood that Smith will be able to hold elections that are free, impartial. After that, we will move on to the consideration of the role that Netburn's profound technical knowledge of the Ripple litigation plays, as well as her anticipated appointment as a district judge for these concerns and other matters involving cryptocurrencies, which will become an essential component of her decisions regarding this case and the others. The crypto community is praising Netburn's approach to the legal system. In addition, the appointment of Netburn to the position of federal judge was met with a significant number of responses from a variety of communities, including the cryptocurrency community. In particular, Paul Gruel, the general counsel for Coinbase, issued a supportive remark and underlined Netburn's performance during the XRP litigation when he referred to it as a seminar, an instruction book for the whole industry. It was her previous criticism of the SEC that had gained her the hearts of the XRP community. This was mostly because she had particularly questioned the Securities and Exchange Commission on their enforcement of the legal concepts. Liz's direction for the rules of the disclosure of drafts of William Hyman's amazing lecture on cryptocurrencies in 2018 for Ripple is one of the most significant issues that she has brought up in this context. This is evidence of her commitment to ensuring that everything is open and fair. Netburn's next step likely to be as a federal judge with the solar gazing for a prominent position in key cases that have to do with regulatory clarity and market advancement in the future. This is in contrast to his previous role as top counsel who worked in the cryptocurrency field. The trial phase of the legal dispute between Ripple and the United States Securities and Exchange Commission began last week. Numerous industry participants anticipate that the disagreement will be resolved or that they will reach a mutual understanding soon. The most recent information regarding the new scheduling order was disclosed by the American attorney James K. Phelan. Magistrate Judge Sarah Netburn has entered the order. Specifically, the request for remedies and the entry of final judgment are the focal points of the action. By the decision made by Judge Netburn, the regulatory body is required to submit its answer by the 29th of April. while Ripple is given 3 business days to respond after that. Following Netburn's recent nomination to the position of district judge in the Southern District of New York, the most recent action regarding the case has taken place. Her prior actions have indicated that she has a somewhat positive attitude toward Ripple's native coin, which has provided the XRP army with the confidence that a significant court victory for the firm may be on the horizon. My understanding about XRP is that not only does it have a currency value, but it also has a utility, and that utility differentiates it from Bitcoin and Ether. The judge remarked in 2021, according to counsel Jeremy Hogan, this statement was made about blockchain technology. The various potential outcomes. A recent statement made by Hogan hinted that the litigation would be officially resolved sometime over the summer. People with the possibility of a settlement of $100 million. I am stating that the judge will order Ripple to pay a penalty of $100 million, but he will throw a bone to the SEC and order Ripple to pay no disgorgement. In the past, the Securities and Exchange Commission has attempted to levy a fine of $2 billion against the company, stating that it had violated several XRP sales regulations. Ripple, for its part, contended that its native coin should not be classed as a security and, as a result, should not fall under the authority of the agency. Yet several significant arguments were presented by Stuart Alderety, the chief legal officer of the corporation, in support of the idea that the penalty should not exceed $10 million. The cryptocurrency known as XRP, which is associated with Ripple Labs, has recently been the subject of a flurry of activity as whales exchanged several coins totaling 180 million. Intrigue has been aroused within the cryptocurrency world as a result of this development, particularly about legal processes and the current dispute between Ripple and the Securities and Exchange Commission. Due to the nature of the timing of these whale trades, concern has arisen regarding the possible repercussions for the market. The price of XRP demonstrated a slight improvement, which resulted in a noteworthy increase in the amount of attention paid to the cryptocurrency market. On the other hand, the focus rapidly switched to the activities of huge holders, sometimes known as whales, who were responsible for several significant transactions that involved more than 180 million XR tokens. As a result of these activities, which were reported by Whale Alert, there was a transfer of 26.67 million XRP from Binance to an unknown wallet. This transfer sparked confidence among investors regarding the possibility of an increase in the price of blockchain cryptocurrency. The movement of 100 million XRP between 2 wallets that have not been named is yet another major transfer that has further fueled suspicion among the communities surrounding the cryptocurrency. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and have consulting with a knowledgeable professional.